All right, welcome back, students. In this video, I'm going to cover temporary relief. So a motion for temporary relief, you can begin your education on this as a paralegal is by accessing and looking at Florida Family Law Forms 12.947. Yep, 12.947. So take a look at those forms and after you watch this video, and then you'll be able to get some idea of what a motion for temporary relief looks like. So what is temporary relief? Well, it's a motion that's filed shortly after the dissolution proceedings have been filed, after some initial discovery has been done, that sets the stage for the remainder of the litigation. And you often find these motions filed in cases where one of the spouses is a breadwinner and the other spouse is not, because there's a lot of issues that that come up. And one of the goals of a temporary relief hearing is to get a temporary order that establishes some sort of equilibrium, that restores some sort of equilibrium that's been that's resulted from the disequilibrium of the divorce proceedings. So what are the issues that are decided at a temporary relief hearing? Well, if you look at those forms, you'll see that they are issues dealing with the marital assets or liability, the marital home, parental responsibility and timesharing, also known as child custody, alimony, child support, and attorney's fees. So all of those issues can be heard and decided at a temporary relief hearing. Now, the temporary relief hearing is sort of like a mini trial, and it's very important because it sets the stage for the remainder of the proceedings. And psychologically, the parties get accustomed to what is decided at the temporary relief hearing. And that is in terms of how much money and alimony is paid, what the time-sharing schedules look like for the child or the children, who gets maybe exclusive use of the marital residence, and who ultimately gets the marital residence. So these hearings are very important for a lot of different reasons. Now, legally, how is a temporary order different than, say, the final order? Is the judge looking at different standards? Well, yes. So the judge doesn't necessarily look at different standards. The judge has to look at the law and basically decide in a quick, abbreviated, I call it a mini trial, what to decide to do on a temporary basis. And because of this, a temporary order is very difficult to have changed at the appellate level. The appellate courts have decided and said that because of their abbreviated nature, because the judge does not have all the material before him to make a thorough and sifting review of the evidence, that they're going to give the judge very broad discretion, which means the judge basically has the right to decide what the judge thinks is proper. And it will only be disturbed on appeal if there's a compelling reason. If there's just some totally out of whack alimony award, for instance, based on the evidence that was presented, that can get overturned. But in general, they won't be disturbed. And again, the reason is because these are abbreviated, short hearings compared to a final hearing, and the judge always has the chance to change it in the final judgment. So that's my introduction to temporary relief. If you have any questions, please let me know. And again, as a paralegal, you'll probably be charged with drafting up these motions. So take a look at those forms and become familiar with them. And I'll see you again next time.